Well, a whole bunch of people want to get their hands on the president's tax and financial records. Multiple parties, congressional, state subpoenas, you name it. The Supreme Court will be considering this, is going to take up the case. This was the last stop the president had pushed to make sure they would, and they are. Now, of course, the devil is when it comes out and what the decision will be. A guy who's quickly becoming a favorite guest of mine on all these legal matters involving Constitution and impeachment, all that. Attorney Sam Dewey joins you right now. Sam, good to have you back.
Thank you again, Neil.
Timing of this, Sam, is everything, right? I mean, this would be a decision that the Supreme Court could conceivably make June, July. But where do you see this going?
Well, I think the court is going to move the case fairly quickly. They granted review in all three cases today, the tax case as well as the accounting cases. And they've set all those cases for argument in March of next year, which is a shortened briefing schedule. And then I expect they'll try to rule as quickly as possible. But I think you're right. We probably won't have a decision until June or July because this will be, it is a complicated case, and it's a case that they're going to want to be careful with.
Now, if memory serves me right, said they had at least agreed to put a stay on getting any of this stuff out or risking getting it out in anyone's hands until they decided what they were going to do on deciding this, on taking the case up. So now what happens?
So all the lower court orders are now stayed until the Supreme Court decides the case. So the committees don't get the information, and District Attorney Vance doesn't get the information until the court rules on the merits of the case now.
The only one I could think of, Sam, of similar potential magnitude was the Supreme Court taking up the issue of Richard Nixon and all the tapes and releasing them. And I believe that was a 9-0 vote that demanded the president release them. Do you see a vote that would be that decisive one way or the other?
I don't necessarily think so in this case because both the opinions below were split opinions. On the three-judge panel, and then in the D.C. Circuit, in the Mazars case, there was a petition for rehearing en banc, and multiple judges dissented. That was not the case in the Nixon tapes case, so I think there is more of a potential for a split here.
All right, so back to impeachment, if you'll indulge me, Sam, and that is what happens now. It looks like a foregone conclusion once this clears Rules Committee and all the other stuff, and then up and down vote in the House, that along party lines, largely the president will likely be impeached in the House. It'll go nowhere in the Senate. There's been some controversy here about how quickly Mitch McConnell indicates he wants to get this done. The president was open to wanting witnesses, even the Bidens, what have you. What do you think is going to happen there?
So I think it could unravel in one of two ways. And I think as to the president's views, the way I've taken his comments is he just wants a fair process. Beyond that, he's open to letting the Senate work his will. And what I think we could see is either some variation off the Clinton process, where it's mainly arguments with maybe a few closed-door witness depositions, or we could see a more fulsome trial with witnesses being called to testify in the Senate. I think it'll be one of those two, which I'm not sure.
So, real quickly, I know the Supreme Court, the Chief Justice, would be involved in that, but he has no say in how the Senate conducts this, right? The Senate is just going to say, oh, we're not going to have witnesses. This is going to be very, very fast. What is his role in that?
So as to whether or not to have witnesses, unless the Senate adopts special procedures under the existing rules, a witness would have to be called by a special order, which would be a motion any attorney or any senator can make, and then that would be voted on a 51 vote threshold. There is precedent for the Chief Justice to break a tie on a procedural motion, but in today's day and age, I don't see Chief Justice Roberts doing it. The last time that happened was Chief Justice Salmon Chase in the Johnson trial.
Wow. You are an encyclopedia, young man. Thank you very much for fielding one question after another. Sam Dewey, excellent read of all things impeachment, controversy, balance of power, you name it.